Hi everyone, my name is Beverly Allen. I am a Tacoma-based attorney. I've been practicing family law for 10 years, and I'm excited to partner with the Pierce County Law Library for the Vibrant Community Video series. And today I'll be talking about what documents you need to draft a petition for a parenting plan. So at this point, I'm going to share my screen. What you see here is the courts.wa.gov website, which is where you find your forms. And so let me take you there from the beginning, just because there's a few buttons you need to click on first. All right, so the main page of courts.wa.gov looks like this. For forms, you'll want to click on the Forms tab and then go to All Forms and List of All Forms. This takes you to the page we started out on. On the left, the List of All Forms, you'll see a variety of different subtopics. As you can see, the one that I click on the most is the family law forms. And for a parenting plan, so first of all, you want a parenting plan if you have a child in common. For the purposes of this video, I will be talking about the situation where you're not doing a parenting plan as part of a divorce. Instead, what I'll be looking at is if you have a parenting plan that's needed because you are not married to the other parent, but you don't have an enforceable court order that talks about visitation. So in order to start us out, we will be looking at the FL Parentage 331 form. So I'm going to click on that form. By the way, it's important for Pierce County purposes that you start off with the Word document so you can type into the form, but that where you end up is a PDF version. So you should be able to print this as a PDF or save it as a PDF using most word processing suites. All right, so this is what the petition for a parenting plan looks like. And this is, again, it's meant for situations where you've had an affidavit of paternity, so you've had an acknowledgement of paternity, but you're not married to the other parent. So most of this is biographical information, what your name is, the children's name, their ages. The court then asks, well, how was parentage established? So an acknowledgement of parentage is one of the best ways to do this, but it's also possible that your case started out with an adjudication of paternity through the courts. So you need to tell the court here in this section, section 3, how parentage was established. If you have a birth certificate or the affidavit of paternity, you also need to file that into the case so that the court can see that paternity has been established. And so again, section 4 also asks you about the acknowledgement of paternity. Section 5 asks you which state it was filed into and whether or not 60 days have passed, because if it's been more than 60 days, then the deadline to rescind the acknowledgement of paternity has passed. So the court is going to be interested in whether or not that deadline has passed. Now, this is also important. If it's been more than 4 years, the person who signed the acknowledgement of paternity cannot challenge the paternity itself. So the court wants to know also whether or not it's been more than 4 years. If it's been less than 4 years, then the person asking for the parenting plan, it's usually also the acknowledged father, and there's no reason for them to challenge that paternity. There are also sections dealing with jurisdiction, including section 6 and section 7. Section 7, the court wants to know where the child's been living if the child has not been living in Washington. And so there's that section as well. Section 8 This comes up a lot in parenting plan actions as well. The court wants to know if someone else has a legal right to the children. So this usually means if somebody else has filed a third-party custodian petition. And if they have, then that person might have a legal right to the child as well. Then you'll address whether there are other cases involving the child and whether or not Washington has already made an order, or whether this is the child's home state. It's the child's home state if they've been living in the state for more than 6 months. Now, when you're going through these forms, it's very important that you check all of the boxes that apply and that you address all of the sections. If something doesn't apply, you may want to take the extra step of saying not applicable or crossing it out, some way that you can indicate to the court that you have in fact read the form and that you're filling out the entire form. All right, so then the court wants to know if there's already been a parenting plan or schedule. If so, you might want to consider that you're filing the wrong petition. It may be necessary for you to file a petition to modify if there's already a parenting plan. So child support. I'm going to show you some other forms relating to child support because if you don't have one administratively, meaning you haven't asked the state of Washington to enter a child support order, you will want to ask the court to file a child support order. Whenever you're filing a child support order, you also want to file a financial declaration. A financial declaration helps you break down what the income of the parties is. And this is what the financial declaration looks like. It is found on Form FL All Family 131. What it is it's a budget. So Section 3 deals with income, Section 7 deals with expenses, and you'll also want to provide financial records in order to support your income and expenses. Those need to be filed under a cover sheet, which is found at courts.wa.gov as well. It's found under FL All Family 011, and the form tells you that. There's also, it's important to correctly calculate your income. So in Section 3, it indicates how often are you paid, and there's a formula for how to determine your income based on how often you're paid. If it's weekly, then you multiply your weekly pay stub by 4.33. If it's twice a month, you multiply it by 2. If it's every other week, then you multiply it by 2.15. There are other ways to calculate income as well. For example, you could take your W-2 from the prior year and divide that by 12 for both your income and your taxes. You can also figure out how many months that the most recent pay stub has covered, and you can divide it by the amount of months. There are other ways to average income as well, but be prepared to explain to the court in your calculations why you are using some other method other than just using the current pay stub. By the way, if your income is disputed or if you've done an average, then you'll want to use Section 5 to explain to the court why the court should accept your income numbers, either for yourself or for the other party. If you think it's likely that the other party is going to dispute the expenses or debts you list, you should use Section 10 to explain that as well. So in addition to the petition for the parenting plan and the financial declaration, this document here, FL All Family 139, is a very useful document for your petition because it explains to the court how you've done parenting functions for the child. And this is very important for the court to determine, do you have a close and bonded relationship with the child? Are you able to take care of the child's needs? Does the other parent have a close relationship with the child? What is your work schedule? What is the other parent's work schedule? These are all very important factors in drafting a temporary parenting plan. So this declaration is how you do that. So what have we talked about so far? We've talked about a summons, we've talked about a financial declaration, we've talked about the information in support of the parenting plan. You'll also want to fill and file the summons, which is going to be FL All Family 330. So the summons and the petition both need to be personally served on the other parents. And your proposed parenting plan also needs to be personally served. The summons lets the other parent know what form they need to use to respond, how to get that form, how to get help, what court to file it into. So if you don't have the summons completed, then the court won't be able to finalize your case or even move forward on your case. The actual parenting plan itself will also need to be completed and filed, and that's FL All Family 140. And this section also has some biographical information. The most important sections, again, fill out every section, check every box that applies, but you'll want to focus particularly on sections 4, 8, and 10. So section 4 applies if there are limitations that you've indicated to the court in section 3. So if a parent has drug problems or some other emotional or physical limitation, you'll want to address that there. Section 4 you'll want to complete in lieu of doing a parenting plan if you want supervised contact or no contact. Section 8 is the school schedule, where you say which parents the child should live with and how often they should see the other parent. Section 9 is then the summer schedule. You can choose to keep the same school year schedule, do a vacation schedule, or do an alternative schedule. And section 10 is the holiday schedule. A lot of these single day holidays, it makes sense to have the children go with the parent for the attached weekend, but really this is your opportunity to customize your parenting plan. Speaking of customization, section 14 allows you to put other types of requirements, such as no one can discuss court documents with the child or show the court orders to the child. So that's a very important section as well. So these are some of the most important sections for your parenting plan. I encourage you to go to Washington Law Help for more information, or to the Pierce County Law Library, or you can also visit my website, which is TacomaLegalCoach.com. I also have a Facebook page. I'm happy to take your questions either about parenting plans or any other family law topic. Thank you so much for tuning in.